Hello, everyone, and thank you for joining us for today's webinar. For those of you who don't know me, my name is Joanna Sutton. I'm a Principal Associate here at Knockholds in the employment team based in our London office, and I'm joined this morning by my colleague Rachel Davis, who's also a Principal Associate in the employment team based in our Bishop Stortford office. So today we are going to be looking at the rights that an employee has to take time off of work for family-related reasons, or to ask for a change to their working arrangements because of caring or family responsibilities. When we run seminars and webinars, we always ask for feedback about topics that you'd like to hear about, and this is one that's come up quite a lot recently. So it's obviously something that you're all grappling with. That's partly, I guess, because there are so many different types of leave that an employee can take, and because of the fact that employment law is always changing and evolving and there's new trends and things like that. So there's a lot, as always, to keep up with. But also, I think a lot of it's come out of the pandemic, and because throughout the pandemic, when employees were working at home more, although it was obviously very difficult, in some ways it was easier to balance home and work responsibilities. But now with the world returning back to some sort of normality and employees coming back to the office or their usual working arrangements, spending more time commuting, things like that, they're finding it more difficult to balance those responsibilities. And so some of these rights are now becoming more prevalent within the workplace, and certainly employees are asking for more and more time off to deal with their family responsibilities. So it's important to be aware of the types of leave that are available. So that's really what we're going to recap on today, and also to make you aware of the times when it's okay to say no to an employee who wants to take time off for a family related reason, and the circumstances in which you can do that. So that's essentially what we're going to be looking at today. We'll be talking for about an hour or so. We're very happy to take questions. We'll probably deal with those at the end, so please feel free to put those in the chat box, and then Rachel and I will pick them up at the end. So starting off, we're going to be looking at the beginning, so when somebody becomes pregnant, what their rights are at work. Then we're going to be looking at some of the types of leave that you might be more familiar with, so things like maternity and paternity leave. But then we're also going to be looking at adoption leave and shared parental leave. And then I'm going to pass over to Rachel, who's going to talk about some more of those types of rights that would apply throughout the time that an employee is working for you with a child under the age of 18. So Rachel will be looking at ordinary parental leave, time off for dependents, parental bereavement leave, and flexible working. So that's a rough overview of the types of topics that we're going to be looking at today. So I'm going to kick off with looking at pregnancy rights at work. So at the start of that, I thought the best place to start would be to look at pregnancy discrimination, which is obviously something that as an employer, you will always be kind of conscious of issues in that sense arising. And people often say to us as employment lawyers, oh, things like that don't happen anymore. People don't say outrageous things when an employee is pregnant at work, but I can assure you that they absolutely do. So I'm going to start from the beginning and just cover the basics about what you need to be aware of in terms of the risk of discrimination, and then we're going to go on to look at the different types of leave. So it should be obvious, but employees are protected from being discriminated against, so treated less favourably because they're pregnant, or because they're unwell as a result of being pregnant, or because they have said that they want to take maternity leave, or they have taken it. So they are protected from discrimination from all of those things. And again, should be obvious, but they shouldn't be excluded from being able to train. You shouldn't think just because an employee's told you that they're pregnant that they won't be interested in a promotion opportunity, and so exclude them from those discussions. They should absolutely still be, considered as a potential candidate in those sort of promotion prospects. In the same way, you shouldn't demote them just because they're pregnant. Again, sounds obvious, but you'd be surprised at how often these things come up. You can't change their duties in a detrimental way unless there's a reason for it, which we're going to go on to look at kind of the health and safety and risk assessments that you need to do. But you can't just take responsibilities away from them because you think, well, they're not going to be here in 9 months' time, so we'll pass that on to somebody else who's going to still be within the organisation. And equally, you shouldn't pressure them to resign or dismiss them. Again, sounds obvious, but you'd be surprised kind of how often these things do come up. So the protection that an employee has when they are pregnant starts from the point that they become pregnant and lasts until the end of their maternity leave. So it's a fairly significant period of time that they have this enhanced protection. And it's important to be aware that the tribunal claims that an employee can bring, it isn't one of those rights that they have to have a minimum length of service. So they can have those rights from the very beginning, from the start of their employment. And indeed, if somebody comes for an interview with you and they are pregnant and you decide not to give them the role because of that, they can still bring a discrimination claim if they feel that they've been treated less favourably because they haven't been given the job just because they were pregnant. So it's important to be alive to, you know, these risks from the very start of the pregnancy, as I say, throughout to the end of the maternity leave. So next slide. There we go. So often employers will ask us, when does an employee have to tell us that that they're pregnant? And particularly through COVID, what we've seen with a lot of employers is that when people have been working at home and you have only seen this bit of somebody, that you wouldn't necessarily see a growing bump and things like that, like you would normally see if they were walking around the office. And so employees have started to notify the employer a bit later of their pregnancy, but the law says, you know, they can absolutely do that, but they have to tell you no later than 15 weeks before the date that they're due. So it's fairly late stage that they would have to tell you, but obviously in a lot of circumstances you may realise before then, or the employee themselves may tell you before then, because they might be, you know, suffering from morning sickness, or they might find that there's adjustments that need to be made to their duties at an earlier stage, or that they would find beneficial. So it may be that they tell you sooner than that, but otherwise the latest they have to tell you is 15 weeks before the date that they're due. And when they can take their maternity leave at any point they wish, really. The earliest it can start is 11 weeks before they're due, but again, employees tend to sort of leave it later so that they can maximise the period of time that they are able to take for the maternity leave. When an employee tells you that they're pregnant, often clients will say to us, you know, if it doesn't happen particularly often, or you haven't got, you know, you've got a very male heavy workforce, you might not sort of know how to respond. So the requirement is that you respond to that notification in writing within 28 days. And I think it's important to remember that from an employee perspective, this is a big thing for an employee to tell an employer. Potentially they might be quite nervous, they might be concerned about their you know, prospects of promotion, or how well that news is going to be received. So it's really important to think about how that's being responded to. For those of you who are in, you know, HR positions, you'll absolutely be alive to that, but it's important that managers within the organisation are aware of it as well, because it's how they're quite often that first point of contact. And so you can imagine that sometimes the news it isn't quite so well received. From an employee perspective, they'll be nervous, they'll want to know, you know, what they need to do and what their rights are and what they're entitled to. So a good starting point really is for them to be provided with or pointed to a copy of your pregnancy or maternity policy, if you have one, because that's going to set out all the information that they need normally about, like, notification and time off and things like that, and the pay that they're entitled to. So that's a good place to start. But yeah, responding to them within 28 days and making sure that your managers are responding appropriately is essential. So and that's really, as I say on the slide here, because of the risk of discrimination claims. So as I say, these are kind of examples of things that I have been told by employees that come and instruct me for, you know, discrimination claims that has been the response. So, you know, things like an employer saying, oh, you know, oh, great, not again, you know, what do you think this is going to do to the rest of the team, and how are we going to cover your work now? So that is absolutely not the sort of thing that you should be saying, even though realistically from a business point of view that may well be what you're thinking, but instead you should respond in a positive way because of the risk of them saying that they've been discriminated against. So, you know, absolutely say congratulations, you know, let's sit down and have a time to talk about your plans and when you're thinking about taking maternity leave and what the options are and all the rest of it, rather than, you know, that kind of negative comment, which, as I say, happens more often than you would think. So then once you're aware of the pregnancy, you need to consider health and safety and undertaking a risk assessment. So you'll all be familiar with the fact that as an employer, you've got a general duty for all of the staff that work for you to undertake a general health and safety risk assessment to make sure that the environment that they're working in is safe. So that, as part of that general risk assessment, you should be considering, is there a specific risk for employees who are of childbearing age or who are pregnant or who are returning to the workplace, you know, and are still breastfeeding and things like that. So there should be that general consideration about the operations that you have, and particularly if you're in like manufacturing or some kind of factory setting, those risks may be more prevalent. So it might be that, you know, your workplace has a lot of chemicals or things like that that could potentially be detrimental to a woman who's pregnant or likely to become pregnant. But equally, in lots of other sort of areas of work, you know, if you work in a very high pressured environment, there may be a risk of work related stress. There might be, if you're working in retail, a risk of kind of standing for too long. So all of these things should be sort of taken into consideration as part of that early general risk assessment. But then once you become aware that the employee is pregnant, you should undertake a further risk assessment to see if their specific duties that that employee is undertaking are likely to cause them any harm. So that should be done at the point you've realised about it or you're notified of the pregnancy, but also when that employee returns to work, if they return within 6 months of having given birth, or if they return to work and are still breastfeeding, there's still risks that that could be posed to them. So that risk assessment's really important. And obviously, if you identify a risk in the normal way, you should take steps to either remove or reduce it. So that might be, adjusting duties. You might want to change hours of work. If, you know, an employee is perhaps traveling on a packed commuter train, it might be better for them to move slightly, start slightly later and finish slightly later just to avoid rush hour. Those kind of things, just looking at the risks and particular risks, obviously, within your workplace. And the law says if it's not possible to remove or reduce those risks altogether, and this is pretty rare that it would happen, but again, in kind of manufacturing or factory type settings, it may be the case. If the risk can't be reduced or removed altogether, you should think about then putting the employee into an alternative role. So if they worked on a production line or something like that that involved lots of chemicals, and there was another job that they could be put in a separate part of the business that wouldn't mean they were exposed to that, and that risk could be removed, then absolutely you should consider sort of moving them to that alternative work. And in a very rare circumstance where alternative work is not available, then the law says that they have to be suspended from work on full pay to protect them for as long as necessary to avoid the risk, which, you know, if that's an essential part of your business and a core part of their duties and there's nothing else that they can do, that may be for the full period until they take their maternity leave. So really important to be aware of that. As I say, quite rare that it comes up that an employee would have to be suspended for such a long period of time, but certainly a right that's there. So definitely be alive to that. And then something else that comes up, obviously, when a woman is pregnant is taking time off for antenatal appointments. And the law says that they're entitled to paid time off for those appointments. So it's not just medical examinations, it's not just the scans. It could be, you know, if the midwife has said that they should go to relaxation classes or something like that, and it's, you know, recommended because of their particular pregnancy, potentially that can be an antenatal appointment as well. So it's usually around 7 to 10 antenatal appointments that are required, and you have to allow them paid time off to attend those. It includes the time that it takes for them to travel to and from the appointments, not just the kind of appointment time, and you shouldn't be asking them to make up the time because of taking that time out. In certain circumstances, it could be that you have a discussion with them about when those appointments take place, and say, for example, they're travelling to a clinic that's much further away from their normal home address, then in some circumstances it might be reasonable to have a conversation about it. But generally, you, as an employer, you're expected to allow them to take that time off for the antenatal appointments and to pay them. And then if you have a employee who is the partner of an employee who's pregnant, doesn't necessarily have to be your employee that's pregnant, but it's a father that works for you who's due to have a baby, they have the right to some time off their antenatal appointments as well to accompany their partner. So they just have the right to 2, and the law says in that circumstance it's limited to a maximum of 6.5 hours per appointment, including the travel time. So equally, something that isn't just affecting the pregnant person. If you're employing the partner, then there's the right to that time off for the antenatal appointments as well. And similar rights apply in adoption circumstances. So in this section, I'm going to be talking about kind of the rights of a pregnant woman and the partner, if the partner works for you, but also we think kind of traditionally about maternity and paternity, but obviously there's similar rights for adoption. So when you're adopting, you have to have loads of different appointments to kind of go through the selection process, and the law says that you're entitled to up to 5 adoption appointments if you're kind of classed as the main adopter, so the same kind of role as the mother would have in a maternity situation. And then the partner has the right to attend up to 2 adoption placement meetings as well, so mirrors that kind of right for the partner to take 2 antenatal appointments. So then thinking about the rights that a pregnant woman has while she's working for you if she's unwell, and obviously that happens quite a lot, and particularly if somebody's having a difficult pregnancy, they could be taking quite a lot of time off sick. And really, because of the risk of discrimination, again, if that person wouldn't be in the situation if they were not pregnant, so the illness is pregnancy related, you need to be particularly careful about allowing them time off. So obviously treating it seriously, being as flexible as possible. As I say, if it's morning sickness or something like that, then they might find it better to start work slightly later. They might take a while to get going and feel a bit more normal in the morning. So just having that sort of flexibility, if possible, it is really important. And it's also important to remember that pregnancy absence shouldn't be treated as like normal sickness. So if you've got a sickness policy that has a trigger point where you might start sort of capability discussions with them about the amount of time that they've had off sick, any pregnancy related absence shouldn't be counted at all as part of that sickness trigger point. You should look at it completely separately. So yeah, just being flexible, thinking about what you could do, speaking to the employee to see what would help them, and potentially considering occupational health assessment if the employee is really being impacted. You're not expected to come up with all the answers, and so occupational health might be a way to go, just to come up with some solutions if things are particularly difficult for the woman during the pregnancy. So then moving on to look at the different types of leave that are available once the baby arrives. So in this section, I'm going to be talking about maternity and adoption leave, which are more or less similar kind of lengths of leave. And then I'm also going to look at shared parental leave, which is something that was introduced a few years ago and essentially allows 2 parents to share what would traditionally be the mother's maternity leave, to share caring responsibilities for the child. So a lot of these types of leave are similar and sort of overlap. So I've tried to sort of consolidate them to save me repeating myself. I'm going to sort of look at them as a whole and then let you know where they're slightly different rights apply. So as I say, maternity, adoption, shared parental and paternity leave. So looking then firstly at adoption leave might be something that you don't have come up quite so often within your business, but the right to adoption leave essentially arises where you're adopting a child through an adoption agency, or you have a surrogacy arrangement in place. It doesn't apply if you're adopting a stepchild or something like that, or you've arranged your own adoption. It only applies in certain circumstances. that right to take adoption leave applies from the very first day that someone starts with you, so they don't have to have a minimum service requirement. They do for pay purposes, for adoption pay, but not for the right to take the leave. And as I said, in the same way as maternity leave, where there's one person who takes the bulk of the leave, that happens as well in adoption leave. So the main adopter or the main carer would take the adoption leave, and the other parent then has the right to paternity leave, which we're going to go on to look at, or they could both kind of share the parental leave between them, which we'll look at as well. So maternity and adoption leave are more or less exactly the same in terms of the length of the leave that you can take. So you're entitled to take up to 52 weeks leave, regardless of how long you've worked for the employer. And that's 26 weeks of what's called ordinary maternity or adoption leave, and 26 weeks of additional maternity or adoption leave. Where there is a woman working for you who is actually having the baby, giving birth to a child, there is a requirement for compulsory maternity leave. So in most industries, that's just going to be 2 weeks after giving birth that the mother has to take off to, recover from the birth. But in factories and that kind of industry, the compulsory leave is 4 weeks. So that's the minimum that anyone has to take, either 2 or 4 weeks, depending on the industry that they're working in. And then I said I was going to talk about shared parental leave, which is, as I said, just where parents can share the caring responsibilities between them. So that applies throughout a child's first year. So after they've taken that compulsory maternity leave, the mother can decide to bring her maternity leave to an end and then to exchange it for shared parental leave, which she can share with her partner. So up to 50 weeks leave is available for shared parental leave once that kind of compulsory period is out of the way, and they can share it in any way they want. So some parents would choose to both take the time off at the same time, so that they can both be together during those early stages and sort of bond with the baby together, or it could be that they decide to take it in turns. And actually what can happen with shared parental leave is that you can dip in and out of it. So with maternity leave, you just have to take one massive chunk of time off, but with shared parental leave, you could take a month off and then go back to work for a bit, and then take another month off in a bit further down the line. And some parents find that to be quite useful, because it means that they can share their caring responsibilities without perhaps there being an impact on either parent's career or prospects of promotion and stuff within the business. It means that you don't have that extended time off where you might be losing touch. But from a business's point of view, you can imagine it's quite disruptive to have somebody kind of coming in, doing a bit of work for a while, leaving, coming back again. But it's important to remember that right is obviously available, and that is how shared parental leave is intended to operate. So, as I said, the leave can be continuous, and if they say, okay, yeah, I want to take 3 months of what would have been the mother's maternity leave and in one block, then an employer has no right to refuse that. But if you're saying, yeah, you want to do a bit of time off, bit of time coming back to work, and then a bit of time off again, that's called discontinuous leave. And in those circumstances, as I said, it can be disruptive, obviously, to a business, and you do have the right to refuse a discontinuous leave request. There's very complicated rules about when notice has to be given and when it can be withdrawn, and basically you're allowed 3 chances to request the leave, and then you come to an agreement with the employee. So this is one of the things that has made shared parental leave, I think, be less attractive to people, because when you actually look at the rules, it's really complicated. Employees don't really know where to start, and employers equally. So I'm not going to spend loads of time breaking down kind of all of the notice requirements, but what I would say is if you do get a shared parental leave request, just because of the kind of complexity of the rules surrounding it, it's always a good idea to take advice from us, so that we can then kind of talk you through the process and make you aware of when you can refuse it, and what the rules are about responding to requests, because as I said, it is complicated, and there are circumstances where it can be refused, but you need to tread carefully just because of the risk of discrimination claims or treating people unfairly because they've said they want to take it. So then looking at pay, the law says that for maternity and adoption, the statutory position, so the minimum you have to pay is 39 weeks statutory pay, provided that the employee is eligible. So that requires them to have worked for you for at least 26 weeks before 15 weeks before the baby is due, and statutory pay isn't the employee would not have to pay it back if they decide not to come back to work, so it's payable regardless, so they're entitled to that pay, and if they decide not to return to work, then they don't have to reimburse you for it. Many organisations now obviously decide to enhance their maternity and other sort of family pay. So if you do, then we would normally recommend that you put a clause in that says that you require the employee to return to work for a certain period of time at the end of the leave, really as an incentive for them receiving that enhanced pay, and so that then you know that they're going to be coming back at the end of it, and there's always the option to put in there that if they don't, then they can be required to repay it. And as I say, that's something that we normally recommend, and it's quite commonplace. Employees expect that usually if they're receiving enhanced pay for this type of leave, but there's no legal requirement to enhance it, and the statutory position is that you if you're eligible for it, you get it for 39 weeks. So the rate is for maternity and pay is 90% of the employee's average earnings for the first 6 weeks, and then for the next 33 weeks it's payable at the rate set by government. So currently it's £156.66 per week, or 90% of the employee's usual earnings per week if it's lower than that statutory amount. And throughout the maternity period or the adoption leave period, the pension contributions continue. It still has to be subject to tax and national insurance if applicable, and then the final period after you do 6 weeks at the 90%, 33 weeks at the statutory rates, and then the final 13 weeks are unpaid. So there's no requirement to pay the employee anything at all during that final 13-week period. Now with statutory parental pay, it's exactly the same. So shared parental, this for the shared parental leave, it's exactly the same, except that the first 6 weeks you don't get that 90% of their normal rate, so you just pay £156.66 throughout the shared parental leave period, whether it's for a man or for a woman, and that can be paid. Obviously you can still pay an enhanced rate if you choose to, but again, no legal requirement to do that. And during the time that an employee is taking this type of leave, it's important to remember what their rights are during the leave period. So their contract stays in place, they're still employed by you, they're still subject to the terms of that contract. So they shouldn't be working for someone else. If you employ them normally full time and you've got provisions in there that say they should just be working for you, that absolutely still continues. They're still entitled to benefits, so people quite often say what happens with company car or private medical and things like that. All of that usually continues. Company car is slightly different depending on the wording of the contract and whether it's expressly meant to be for business purposes, and again we can advise sort of on a case-by-case basis if there is anything like that where slight adjustments need to be made, but generally the benefits continue. Their continuous service still continues as normal. They don't have a gap in their in their employment. It's not broken by them taking this leave, and their holiday still accrues, which some employers are still surprised about, that why should you be getting extra holiday while you're on maternity leave anyway? Isn't that a holiday? Which I'm sure all the women watching this will agree that maternity leave is not a holiday, and so you should be entitled to take the holiday as well. So what often happens then is you tack the holiday onto either the beginning or the end of the leave. So sometimes in the year that the employee is going on maternity leave, they might decide to actually take some of their accrued holiday before the maternity leave starts, and then they add on at the end of it the leave that will have accrued throughout the year. So that's quite often the way it's done. And again, that's normally kind of covered in maternity policies, just to be clear with the employee exactly what their rights are and what they're entitled to. And then during the leave period, they can take up to 10 what are called keeping in touch days or KIT days. And the purpose of them really is just to allow the employee to kind of remain in contact with you whilst they're on leave. So they might come in for a training session or to attend an important meeting. Some employees use it as kind of a way of sort of phasing back into work after the end of their maternity period. So up to 10 of those are available. They can be taken in single days or in a block. It can just be sort of ad hoc, but they're not compulsory. You can't require an employee to take them, but it's important, as part of those questions and employees asking about what they're entitled to and what the options are, that you make them aware that these types of days are available to them. And they're normally paid at full pay. So that's normally a sort of incentive, I guess, for an employee who's on statutory rates to come in and do a day's work. And it's a good way, as I say, of kind of keeping them in touch with the workplace. If the employee is taking shared parental leave, then they can take the same kind of types of days. These are called split days, so shared parental leave in touch days. And actually they are in addition to the KIT days that would have been available. So if you've got a mother who has taken a chunk of maternity leave and had used some of the KIT days, and then she switches to shared parental leave to take part of the remaining leave with her partner, then there may be additional days that are available then on top of the KIT days that she's already taken. So again, just something to be aware of, that not everyone, it's not immediately obvious that may be the case, but in the same way, they're not compulsory. You can't compel an employee to take them. And then something else that quite often comes up is, what do you do when the employee's away from the workplace, and can you be in contact with them, or should you, or what are the options there? So the law says that you can make reasonable contact with them during their leave, and that you should consult with them about any changes to the business. So if it's being taken over or sold or something like that. Obviously, if there's been pay rises or bonuses payable, the employee should still be entitled to them and informed about them. And then any internal vacancies that come up, it's something that they should be consulted with as well, again, so that they're not being excluded from any promotion or opportunities within the business. So it's a really good idea just to sit down with the employee when they sort of, when you're talking about when they're going to take their leave and all the rest of it, just to talk to them about how often they want to be kept in contact with. Some employees will want to know absolutely everything that's going on, and some of them will think, well, I don't really, I'm not really that interested. So just tell me about, important things like when the Christmas party is or something like that. So agree with them kind of how often they want you to be in contact and how that contact should take place. So do they want a phone call, once a month, or do they just want to be sent sort of general internal emails if there's an update that comes around, just so that then you're sort of tailoring it to the employee, but also, because you've got the right to make reasonable contact with them, you can keep them updated really, as much as you want to, but just take into account their preferences as well. And then looking at what happens when you return to work after taking these types of leave. So the general position with maternity and adoption leave is that the presumption is that you would take the full 52-week period unless the employee tells you otherwise. So if they're just intending to come back at the end of the 52 weeks, they don't have to give you notice of that, you know, that is the kind of presumption that that's when they're going to return. But if they want to come back any earlier, or if they change their mind and say that they want to come back earlier than they originally thought, then they need to give you at least 8 weeks notice. And from an employer perspective, it's important to know that they can change their mind more than once if they want to, about when they intend to return. So again, obviously can be quite disruptive from a business point of view in terms of planning and covering their duties, but they do have the right to change their mind sort of as they wish, really, as long as they give you that 8 weeks notice. Then you can't stop them from coming back to work. So the only time that you could say, no, that doesn't work for us, actually, is if they haven't given you the right amount of notice. Obviously, you can be flexible if you want to. You know, you might think, great, we've been, you know, desperate for them to come back. Absolutely, you know, we'll do whatever they want and they can come back next week if they want to, you know, particularly in the current climate where recruitment is so difficult. So don't feel that you have to absolutely insist on that 8 weeks. If that doesn't work for you, you know, you be flexible and allow them to come back sooner if they wanted to, and if it works for you. And whilst they're on leave, obviously you can recruit someone else to cover their work, or you can sort of divvy their duties out to other members of staff, depending on sort of what works for you. And that's something else to kind of think about, I guess, when an employee does announce their pregnancies. Once other people in their team, or sort of if someone is going to be required to cover their duties, it's important to speak to them as well and consider how that's going to impact on them. And make sure that they're going to be sort of supported throughout that leave. And you know, it's equally important for the team as it is for the employee who's going off, because they'll be worried about, you know, all the extra work that they might be required to do. So something to bear in mind. So if an employee returns to work after the end of the ordinary maternity or ordinary adoption leave period, so that's that first 26-week period, they have slightly different rights. So the law says in those circumstances, if they've just been away for 26 weeks, then they have the right to come back to exactly the same job as they left before they went on the leave. But if they return after the additional maternity or adoption leave period, or after more than 26 weeks of leave, then they still have the right to return to the same job. But if it's not available, or it's not reasonably practicable, because obviously that's a longer period of time that they're away from the business, there may have been restructuring or changes or something like that mean that they can't come back to exactly the same job, then they have the right to return to another job that's on the same terms and conditions. So you can't, you know, demote them, pay them less, give them less benefits, you know, give them duties that they're not capable of doing. So it's again something to take advice about, because from an employee perspective, returning to work and everything being different, or being sort of forced into doing something different, can be quite very unsettling, and it needs to be carefully handled. So I would always say sort of take advice about what the options are and how to message that to the employee, just to sort of smooth that transition back into the workplace. Obviously, if they don't want to come back, then they don't have to. Bear in mind, obviously, if there's enhanced pay, that there may be requirements for them to reimburse you for that. But otherwise, they're just required to resign in the normal way, give you the notice that's in their employment contract. So if they've got 3 months notice, then they have to tell you 3 months before the maternity or adoption leave or whatever would come to an end. And something that, you know, as I say, you think doesn't happen, but it does, and the statistics at the moment are that this is happening, you know, very often to women and parents who have taken this type of leave, is that they are made redundant. And the law says, obviously, you can't make someone redundant just because they've taken this type of leave. And if a redundancy situation does arise, which inevitably, you know, sometimes it doesn't mean that you're in a bubble and you are absolutely protected just because you've taken this type of leave. But if a redundancy situation does arise, then the law says that you're entitled to additional protection. So if there are other vacancies that are available, you have to give that to the employee that's returning to leave, in preference to any other employee. and you can't require them to go through some kind of competitive selection process. So you can't interview them or you know, score them like you would in a normal redundancy situation. You have to give that job to that person in preference. So again, important to be alive to that. Obviously, the law doesn't say that, you know, there are no circumstances in which a person returning from this type of leave cannot be made redundant. There are circumstances where there won't be any other roles available and there's nothing else that you can do, and you know, it's one of those things. But important to again take advice just to make sure that that's everything's done absolutely correctly to avoid the risk of discrimination claims being brought. And as I say there, obviously it's unlawful to treat them unfavourably just because they've taken the leave. So that doesn't mean that they're sort of top of the list for the redundancy pile. And because of the fact that this is happening more and more, the government had done a big consultation on this and had announced that they intended to extend that protection from being made redundant to apply throughout the pregnancy. So from the point of the pregnancy being announced, that there would be the right to keep the same job, and that would then apply after returning to work from these types of leave for up to 6 months afterwards. And so quite a long extension of that protection that an employee currently has just whilst they're on leave, but it would apply throughout the pregnancy and then 6 months after the return to work. So the government said, yeah, absolutely committed to that. That's great. We're going to put that into law, but there have been no definite plans announced yet. There was nothing in this year's Queen's speech, as is the case with a lot of these changes that we've spoken about before about various employment related things. The government response is kind of when parliamentary time allows, and so we'll wait to see if that is going to be introduced, but it's certainly something that's on the horizon and has been campaigned for quite heavily because of the amount of women and people who've taken family related leave, unfortunately leaving the workplace through redundancy. So now I'm just going to talk briefly about paternity leave, which again is probably something that you're more familiar with, that applies to the parent who doesn't have the sort of the main caring responsibilities from a time off work perspective anyway. So paternity leave is available to employees who have responsibility for the child's upbringing. So that might be biological father or the partner or someone who is the partner of when you're adopting or you're having a child through surrogacy. And so for that reason, you can see that paternity leave we traditionally think of something that dads get, but women can take it as well. So if you're in a same-sex relationship and you're not the main carer, then you could be entitled to paternity leave, or in, you know, an adoption situation, something like that, it can be that the man is taking the adoption leave and then the other partner is a woman who can take paternity leave as well. So important to not just think of it as a dad thing. The statutory right to time off is 2 weeks leave. You can take that in either a 2-week block, which is the most common, I guess, or it can be 1 week and then come back to work for a bit and then take another week off. And obviously some organisations would offer more than that as the paternity right to time off. You have to take it within 8 weeks of the child being born or of the adoption placement started, and it can't be taken before the child is born. So unlike with maternity leave where you can start it pre-birth, this has to be taken within 8 weeks of the birth or adoption taking place. The rules are slightly different in terms of actually taking the leave, so you don't have to give an exact date when you want the leave to start. So it would be quite common to kind of say, yeah, I want to take it from the day the baby's born or a week after the baby comes or something like that. So once they've given notice, still have to provide at least 28 days notice if they want to change the start date. And it's not possible to refuse or postpone the paternity leave unless they haven't given that correct notice period. So important to be aware of that. And obviously in the same way, you can't dismiss somebody or treat them differently just because they want to take time off for paternity leave. In the same way as the other types of leave, contract remains in place, still get all your normal benefits, still accrue holiday and continuous service, and obviously the employee's got the right to return to the same job. Much easier if you've just got someone out of the workplace for 2 weeks than it is if you've got them out for, you know, for a year for that to happen. But yeah, obvious that is the case. And then the paternity pay is exactly the same amount as that statutory rate for the maternity and adoption and shared parental. So it's £156.66 per week, or 90% of the employee's usual pay, whichever is lower, and obviously still subject to tax and NI, and pension contributions and stuff still continue. So that's my kind of whistle-stop tour through some of maybe the more usual types of leave that you might be familiar with, and sort of what happens from the point of pregnancy and for the first year of the child's life. I'm going to pass over to Rachel now, who's going to talk through some of the other types of leave that might be available.
Thanks, Jo. Hi everyone. I'm just going to follow on now from Jo just to talk about some of the less well-known family-friendly rights that are available to eligible employees, and it's to help employees balance their personal life with their working life in a way that's flexible and fair. And there's a lot of rights now available to not only employees but not only parents, just to help them change their working patterns, to work from home, and just to give them a better work-life balance. So I'm just going to go through some of these now. I'm going to start off with ordinary parental leave. And this is not to be confused with shared parental leave or paternity leave, which is what Jo's just been talking about. This is a right for all eligible employees to take unpaid parental leave for the purposes of caring for a child for who they're responsible. So this right is only available to employees. It's not available to the self-employed or agency workers or contract workers. And it's only available to employees who have worked for their current employer for at least 1 year. And if they have parental responsibility for a child under 18, so this can be the person that's named on the birth certificate, the adoption certificate, or sometimes this is extended to grandparents if the court has awarded an order that the grandparents are responsible for that child. And the leave has to be taken for the purpose of caring for that child under 18. And the employer is required to give the employer some notice. They're required to give 21 days notice of the reason for the leave and the start and end dates of the leave they want to take. So the law doesn't specify how the parental leave must be requested. So employers are allowed the flexibility of how they are going to allow this parental leave to be taken. And even though there's no statutory right to be paid, employers may decide to give paid leave for this, as long as you've got policies and you apply that consistently across the company. So parents or those with day-to-day responsibilities are entitled to take up to 18 weeks unpaid leave for each child or adopted child up until their 18th birthday. So it has to be taken before the child reaches the age of 18. And this leave must be taken in blocks of a week at a time, although in the circumstances where there's a disabled child, the employer can be more flexible, so whatever fits in and is more supportive for the parents. So parents may need to take 1 or 2 days at a time to go to appointments and things like that, rather than taking a block of a week. And the law allows a maximum of 4 weeks per child per year, but again, the employer may apply their discretion and allow the employee more time in a year than the 4 weeks. And a week equals the length of time an employee normally works. So if an employee, for example, works Monday to Friday every week, then those 3 days would be the week that they're entitled to. And the 18 weeks parental leave applies to each child, not to the individual's job. So, for example, if an individual takes 10 weeks in one job and then changes job, they then got 8 weeks to take with their new employer, providing they're eligible. So they've worked there for a year. So it's specified that leave must be taken for the purposes of caring for a child. Even though this isn't defined, it includes things like spending more time with children, as having more family time with the child under 18, accompanying a child during a hospital stay, taking children to look at new schools, settling a child into new childcare arrangements, or looking after a child during summer holidays. So it might be when the employee doesn't want to use their annual leave, or they've run out of annual leave, then they can then request the parental leave for some of these purposes to spend time with the child. So this is a statutory right, so employers can't deny or cancel parental leave, but employers are allowed to postpone parental leave in certain situations, really where there's no other option. So they're allowed to postpone the parental leave by up to 6 months, only if they can show that the employee's absence would cause a serious business disruption. So, for example, if you've got an accounts manager and the accounts manager is the only person you've got, and you come into the end of a financial year, for example, and it's going to cause a real problem to the business if the employee decides to take a particular week off, you could try and postpone this, discuss it with the employee, could give them written notice of the postponement within 7 days of receiving the request for them for parental leave, give them a reason why the postponement is necessary, and provide alternative dates within the next 6 months and consult with the employee about the alternative dates. And of course, you've got to make sure that you're not just going to postpone it so that the parent doesn't then have the chance to take it before the child's 18th birthday. And as with all the other rights, employees are protected from dismissal or detriment for requesting or taking this ordinary parental leave. So I'm now going to move on to time off for dependents. This is otherwise known as emergency leave. So this right has been created to help employees and to enable them to take unpaid time off to deal with emergencies or unforeseen events relating to their dependents. Again, it's only available to employees, not contract workers or self-employed individuals, but this is available to employees from day one. There's no required length of service. And it gives employees the right to take a reasonable amount of time off to care for dependents in emergency situations. So generally this would be, you would expect maybe a couple of hours or a day or two to go and deal with an emergency situation and then arrange more long-term plans. So it depends on the situation. An employer will want to look at things like the relationship between the employee and the dependent that's relying on them, what situation has occurred, and whether there's any other help available for that particular dependent. So there's no statutory right to be paid during this time off, but again, employers can use their discretion, or they might have policies in place where they allow a certain amount of paid time off for dependents' leave. So, as I say, it's got to be a dependent that relies on the employee. This can be a spouse or civil partner, the employee's child, the employee's parent, somebody who lives in the employee's household. So it might be another family member that relies on the employee in emergency situations for care, in the event of an accident, an illness or an injury. For example, it could be a neighbour who hasn't got anybody else and who relies on the employee in emergency situations. So basically, this is the widest of all the family leave rights, as it doesn't just cover children or relatives, but it can also potentially cover neighbours and friends, anyone who relies on the employee for that care in an emergency situation. So, as I say, it's got to an emergency situation and the employee is allowed to take time off for what action is necessary. So it's not available for planned events. It's things that happen where the employee might be at work and they get a phone call and they have to drop everything and just go and sort something out. So this could be an injury or an assault on a dependent, or if somebody has a baby and they go into labour unexpectedly and they're relying on the employee to take them to hospital, for example. So this wouldn't be available for somebody who's arranged to go and help somebody out whilst after they've had the baby or whilst they're on maternity leave, because that wouldn't be an emergency situation. That's something they could plan for. Or this might happen, for example, if there's a disruption of care arrangements. So, for example, if a child's nursery closes unexpectedly and the parent gets a phone call to have to go and collect the child urgently, or if a childminder is sick, when you go and drop the child up in the morning, the childminder is sick and not able to look after the child that day, the employee should be allowed time off to just go and make emergency plans, and then put something in place for the future. So again, it would just be a couple of hours, a couple of days, but then anything longer than that, the employee would then be expected to either take annual leave, unpaid leave, or perhaps the ordinary parental leave that I've just been talking about, or maybe just something related to an employee's child that occurs unexpectedly during school time. For example, you might get a call from the school saying that your child's been involved in a fight or they've been suspended, and the employee needs to just drop everything and go and sort it out in that situation. So no formal procedure is expected to be followed, because obviously we're talking about an emergency situation, so the employee is not going to have time to follow any kind of written procedure or anything like that. They're just expected to tell the employer as soon as possible, give them the reason for the time off, and also how long they expect to be away for in the initial time. And as I say, the employer should treat each situation on the basis of whether they believe the time off is reasonable and necessary. And there's no limits on how many times an employee can take this time off, because who knows, everybody's got different situations, different people depending on them. So somebody might need quite a lot of people depending on them and need a lot of time off in different situations. But there's no right to take time off for a situation which is not unexpected and not an emergency. Some employers may offer compassionate leave, which this isn't a legal right, but some employers do this, and they may offer paid or unpaid time off for emergency situations, such as a death in the family or time to make funeral arrangements. And this might be something employers have in their policies as an addition to this statutory right to time off for dependents. And as with all the other rights, an employer, it mustn't refuse reasonable time off, or treat an employee unfavourably, or select an employee for redundancy, or dismiss them for asking for this time off or for taking this time off. So I'm now going to move on to parental bereavement leave. So this is one of the newest rights that was introduced in April 2020, a new statutory right, and this is also referred to as Jack's Law. And this is following the devastating death of Jack Law, who was a young child who died in 2010 when he drowned in a family pond. And his mum, while she was going through the grieving process, was horrified to find out that Jack's father was only entitled to 3 days paid leave, and then he was required to go back to work. So she campaigned for 10 years to get this new right introduced for grieving parents when they're going through one of the most devastating things that anyone can go through. And they're not only grieving, but they're trying to help family members and make funeral arrangements, etc. So this right to parental bereavement leave has been introduced, and it arises on the death of a child under the age of 18 or a stillbirth after 24 weeks of pregnancy. It's available to employees from day one of employment, so no length of service is required. And it's available to employees who either the parent, so birth parent or adoptive parent, or the partner of a bereaved parent, or someone else who had the day-to-day responsibility for the child. So the employee will be eligible for the leave and may also be eligible for statutory parental bereavement pay in certain circumstances. So employees are entitled to 2 weeks parental bereavement leave, and this can be taken together or as 2 separate weeks, providing the leave starts on or after the date of the child's death or the stillbirth, and providing the leave finishes within 56 weeks of the date of death or stillbirth. And the reason for this is that employees and parents may want to take the 2 weeks together at the beginning when they're going through the grieving process, or they may prefer to take one leave at the start and then 1 week perhaps on the anniversary of the death. So it can be split into those 2 separate weeks. And this parental bereavement leave can also be taken after other types of statutory leave. So it can be taken after maternity or paternity leave, or it can be taken in between the blocks of previously booked shared parental leave between the 2 parents. So all employers have to do, they need to give notice to their employer. There's no formal procedure. It doesn't have to, it can be written, it can be verbal, just giving notice of their intention to take the parental bereavement leave, specifying the date of the child's death, the date on which they want the leave to begin, and initially just saying whether they want to take 1 or 2 weeks leave together. And some employees, eligible employees, will receive statutory parental bereavement pay. So again, they'll get either £156.66 a week or 90% of their average weekly earnings, whichever is the lower. And to be eligible for parental bereavement pay, the employee must have been continuously employed by the employer for at least 26 weeks. They must still be employed at the date of the child's death or the stillbirth. And they must earn an average of £123 a week. And they must just give the employer the correct notice. And if they are eligible for statutory parental bereavement pay, they need to give that notice and request that pay within 28 days. And then finally, I'm going to move on to flexible working. So flexible working has obviously become a lot more common in the last 2 years since the pandemic. There's been a real change in working patterns over the last 2 years. People have been working from home a lot more, and they're wishing to continue to do so in most circumstances where this has worked for the employee and the business. There's many benefits from flexible working, benefits to the employee of a better work-life balance. Employees have been shown to be more motivated, more productive, and it's benefit to businesses. They can show a more diverse workforce, and it helps with recruitment and retention of employees. And flexible working patterns now, being able to work from home, employees see this as a benefit, and they expect this to be a benefit along things like private healthcare and things like that. So this is becoming a lot more common. All eligible employees have the right to request flexible working. They don't have the right to work flexibly, but they have the right to request it. Employers aren't obliged to agree the requests, but they are obliged to deal with requests in a reasonable manner. So if an employer agrees a request for flexible working, they've got to be careful to amend the contract of employment, agree a start date so everyone's clear what the new terms of employment are. And employers can reject flexible working requests providing they give sound business reasons for the refusal. So there's different types of flexible working available. There's job sharing. So this is where 2 employees share the same role and split the hours between them. Working from home, which a lot more people are doing now. So people want to work from home either some of the time or all of the time. Part-time hours, which is usually working less days, reduced days. And compressed hours, which was working the same amount of hours, but compressed into fewer days. Flexi time, where employees work times that suit themselves within reason. So they're usually expected to work core hours, such as between the hours of 10 till 3. Or staggered working hours, where employees are working different start and finish times than other employees. So all employees with at least 26 weeks continuous service have the right to request flexible working. And this is a formal request is known as a statutory request. But employees, of course, can, with less than 26 weeks, can ask for flexible working. It's just up to the employer then whether they want to allow that or not, and then they would deal with it on a less formal basis known as a non-statutory request. But if an employee with the 26-week service who complies with the requirements for making a flexible working request, which I'll go through in a moment, this is a formal statutory request. So then the employer is obliged to deal with it in accordance with the process set out in law. And an employee can only make one statutory request in any 12-month period. So if it's a formal statutory request, the employee has some obligations and the employer has some obligations. So the employee, the onus is on them to put forward the flexible working request and lodge it in writing, stating that it is a statutory request for flexible working. The employee should specify the proposed change to the working arrangements and when they want it to start. And the employee should have this well thought through in advance and indicate the effect the change might have on the business, and if possible, put forward ideas or solutions to how this can be dealt with by the business, so that working with the employer to see how this can work. The employee should indicate whether they've previously submitted a request and when, because they can only submit one request in 12 months. And then if they decide to withdraw the application for any reason, they should tell the employer in writing, so that it's obvious to both parties that that request has been withdrawn and the employer doesn't have to deal with it anymore. The employer then has the obligation to deal with the request in a reasonable manner. So they don't have to accept it, but they have to show that they've dealt with it in a reasonable manner. So this involves considering the request carefully, so taking into account what the employee wants to do, whether that can be accommodated within the business. Discuss it with the employee, preferably in a private meeting, as you would conduct any employee-employer meeting. Be open-minded and positive and aim to find a solution. So you know, don't go into this thinking this is never going to work, we can't afford this, we don't want this to happen, because you've got to be shown that you're dealing with it in a reasonable manner. And then the employer has to inform the employee of the decision in writing within 3 months. So what you might do, you might think this isn't going to work, but you may consider a trial period just to review how the arrangement will work in practice, because you might be surprised and it does work out, or it might then demonstrate to the employee why the arrangement isn't going to work. You might just decide, yeah, you can grant the request, grant it straight away, discuss with the employee how to implement it, and it's always best practice to amend the employee's contract of employment so it's all in writing and everyone knows where they stand. You can reject the request, providing you've dealt with it in a reasonable manner, and ensure that rejection is for one of the 8 permitted business reasons, which I'll go through in a minute. And if rejecting the request, you're not obliged to allow the employee to appeal, but it's good practice to allow an appeals process, because that just again goes to help you to show that you have dealt with it in a reasonable manner. So there are 8 business reasons for rejecting an application. So, for example, if you can show that the extra cost will damage the business. So, for example, if you've got 2 employees who want to job share a role and they both want to work 3 days each, but you can't afford the additional payroll costs and the employees aren't prepared to compromise, then that would be a business reason for rejecting the application. If the work can't be reorganised amongst other staff, so for example, if you've got an employee who wants to reduce their days from 5 days to 4 days, but perhaps they've got a particular skill like a language, which other employees don't have, so you're not going to have that skill on the one day they don't want to work, so that would be a reason for rejection. If you've got an ability to recruit additional staff during the periods of time or the days that the employee is suggesting they don't want to work anymore. If there's going to be a detrimental impact on quality or on performance, so for example, you might have a manager or a supervisor who is requesting to work from home full time, but that's going to have an impact on supervising staff or mentoring people. So again, that would be a reason for rejection. If the business wouldn't be able to meet customer demands, so for example, if someone's suggesting that they work a later shift, they want to start later and finish later, but most of the customers are coming to you in early time during the day, that's when you're busiest, that would be a reason for rejection. Insufficient work during proposed working times, or if the business is planning changes to the workforce, so for example, you might have a shop or a restaurant that an employee is asking to work later, but you're planning to change the opening times of your business to earlier, so that's not going to fit in with the planned changes. So that would be a business reason for rejecting the application. So, as I say, if the request is accepted, this will result in a permanent change to the employee's contract unless you've agreed a trial period. Be clear as to what the changes will be made. And then the employee, once the changes have been made, the employee doesn't have an automatic right to revert to their previous working pattern. If they change their mind, they would then have to make another flexible working request, which of course they can't really do within 12 months. So the employee needs to be clear that this is a change to their terms and conditions once it's agreed. So Employees can bring a claim in the employment tribunal, not just because their request is rejected, but if they can show that the employer hasn't handled it in a reasonable manner. So if the employer, for example, has just turned it down straight away without giving one of the business reasons or without considering it properly. If the employer's failed to respond to the request within 3 months. If the employer refuses it, but they haven't shown one of those 8 business grounds for refusing it. If the employer's treated the application as withdrawn when it hasn't been withdrawn, or if they've rejected an application based on incorrect facts. And again, if they've dismissed the employee or subjected them to a detriment, treated them unfavourably as a result of their flexible working request, the employee has got the right to bring a claim in the employment tribunal. The claim should be brought within 3 months of either the employer's decision, the date that the employee was told that their application was being treated as withdrawn, or the date that the employer should have responded to their request but has failed to do so. So the tribunal hasn't got a power to order the employer to comply with the flexible working request, but they might order that the employer reconsider it on different facts. But in most cases, the tribunal will order the employer to award compensation, and compensation it's not huge, it's up to 8 weeks pay, capped at the statutory maximum, which is currently £571 a week. So even though that doesn't sound such an expensive claim, these claims can be expensive because not dealing with flexible working requests reasonably can give rise to discrimination claims. And these claims can be very expensive. So, for example, they can lead to claims for sex discrimination. So, for example, if you rejected a request from a male employee to reduce their hours, and he can show that you've allowed a female employee to work flexibly, a female employee who's involved in a similar role to him, then he may have a claim for direct sex discrimination because he will be able to show that you've treated him less favourably based on the fact that he's a man. Equally, you could rejecting a request from a female employee could result in a claim for indirect sex discrimination unless the employer can show a legitimate business reason. So a claim for indirect sex discrimination can arise when an employer applies a provision, criteria, a practice which treats a female employee less favourably. So it's a well-known established principle that female employees have the majority of the childcare responsibilities. So if a female employee requests to work flexibly and the employer turns that down without showing one of those 8 business reasons, the female employee could then claim for indirect sex discrimination. And discrimination claims attract compensation which is unlimited. It includes injury to feelings as well as compensatory awards. Furthermore, you can have disability discrimination claims arising from not dealing with flexible working requests properly. So, for example, a disabled employee may ask for a change in their working patterns. They may ask to start later and work later, for example, if they want to avoid travelling on public transport in the busiest times. And that may result in a claim for failure to make reasonable adjustments, which is a duty that an employer has when dealing with somebody with a disability. So these are things to be really careful about when you're dealing with a flexible working request. So a number of claims have come out in the employment tribunal recently as claims for flexible working, as requests for flexible working has increased following the pandemic. And I've just got an example here of a claim that's recently come out, which is just an indication of how costly these claims can be if employers get this wrong. So this is the case of Mrs. Alice Thompson and Scan Crown Limited. So Alice Thompson worked for an estate agent. She worked full time. The estate agents closed at 6 p.m. every night. And on return from maternity leave, Mrs. Thompson made a flexible working request to reduce her hours to finish at 5 instead of 6, so that she could collect her daughter from nursery. The employer didn't consider it at all. They just turned it down straight away, saying that the business couldn't afford to work for her part-time. So they didn't even consider a trial period or consider any kind of compromise. They just turned it down. So Mrs. Thompson resigned. She claimed constructive dismissal on the basis that they had acted so unreasonably, and she brought a claim for indirect sex discrimination, claiming that her flexible working request was not fairly considered. And the Employment Tribunal agreed with her, and they found that making her work until 6 p.m. placed her at a disadvantage because the nursery closed at 5 and she couldn't get to the nursery in time to pick up her daughter. And she was awarded compensation, which included injury to feelings and compensatory for loss of earnings. And she was awarded £185,000. And there's a number of claims that are coming out of the Employment Tribunal. So this is just something to be aware of when you're dealing with flexible working requests. So that's the end of our presentation. We've got time now for any questions. If anybody's got any questions, please feel free to put them in the chat box. Alternatively, Joe and myself are both available, and we'll put our details up with our email and our telephone numbers if anybody wants to contact us directly. I can see we've got one question so far in the chat box. Okay, this is just saying, we think an employee is pregnant, but they haven't told us. How should we approach this? So I think is that one you might want to take, Joe? That's okay.
Yeah, absolutely. Yeah, it's a really tricky topic, how to handle it sensitively. And yeah, absolutely, just need to be very careful about sort of asking that question directly. So I guess, one of the things you can do is kind of take that employee aside and, offer to have sort of a catch up with them, or like a one-to-one, and just see if, basically give them an opportunity to tell you. You really should avoid sort of asking directly, are you pregnant? Because that's quite sensitive to do that. So I think provide the opportunity for them to open up to you. If you think that their work or something like that's being affected, or they're calling in sick a lot, then that might be an opportunity to either think about occupational health assessment, and then that may sort of prompt the employee to tell you, I suppose. Or, if there are sort of issues with performance, you would be addressing those in a normal way if you didn't think that they were pregnant. So, you can still progress those discussions. But yeah, I'd definitely say try not to ask directly, are you pregnant? Because that there might be reasons why they're not prepared to tell you. They might not have told their family and people like that yet. So yeah, just a bit, one to be a bit cautious of, I think. I can see there's one that's come in for you, Rach, which is quite a topical one, just about taking time off. Can an employee insist that you allow them to take time off for school events like parents' evening or sports days?
Yeah, this is a common one as well. So there's no legal right for things like this, because obviously a sports day or a parents' evening wouldn't be classed as an emergency situation, and you wouldn't really be able to take parental leave because that's got to be taken in blocks of a week. So there's no legal right for them to be allowed time off for this. You could use your discretion to do so, and perhaps include something in your policies about having a time off for school events. But if you're using your discretion, you need to ensure it's applied consistently across the company, so everyone's entitled to the same. Or you could just insist that an employee takes annual leave, or if paid annual leave or unpaid annual leave if they've run out of that. But yeah, there's no legal entitlement for things like that.
And then another one that's come in is just about if you've got an employee who's constantly taking time off because their child is ill, and I guess there's kind of a time when kids are at nursery and stuff like that where they tend to come down with all of the bugs under the sun, and take lots of time off. What the question is, what do you have to do if someone's taking lots of time off sick because of or time off work because of children being sick?
Yeah, so that's a difficult one. So, I mean, as we've just gone through, employees do have the right to take unpaid leave off for dependents. It only applies to emergency situations, but again, you have to look at what the situation is. If somebody's constantly taking time off, if they're getting calls from school. I would say discuss it with the employee, find out what's going on. There might be something in the background. For example, the employee's got a child who's got an illness, so they need to be aware of that. If it appears genuine, then I think you just need to go with it, because it is an entitlement. If you feel that they're taking time off and they don't really need to, and they just keep doing it and they haven't given you a genuine reason, tread carefully, because you mustn't treat them, they mustn't suffer a detriment or be dismissed, but perhaps start going through an informal procedure to start with, just to offer them support. Can you offer them that they work flexibly, maybe leave earlier and start later, if that will help them with their childcare. But ultimately, if it continues and there doesn't seem to be a reasonable excuse for doing this, then you would deal with it as you would normally deal with misconduct or incapability. But just tread carefully, because it is something that is available as a right to them.
Sure. And then another question has just come in. If a company, referring to the employment tribunal case that you spoke about, if a company has one employee in the office and they request flexible working, which doesn't cover hours that the office is open, what's the responsibility then to offer flexible working?
Well, again, I mean, you don't have to accept a flexible working request. And if you're saying that they're requesting flexible working which doesn't cover the hours the office is open, then that would be one of the business reasons. It's a business reason, a reasonable one, because they're asking to work when the office isn't open. So you can turn down that request.
Yeah, absolutely. I mean, yeah, so it all comes down to sort of reasonableness and being seen to be genuinely considering it, but you don't have to sort of change the way that your business operates just to accommodate that flexible working request. The rights to request it and not to be granted it necessarily. So yeah, totally agree with that. Don't know if there's any more. I've just had one come in. I've heard that we need to take a flexible working request every 12 months. If the request is granted, is it permanent? What happens if the condition is changed and the person doesn't need it anymore? So I think in that circumstance, yes, the employee only has the right to request flexible working once in every 12-month period. If you grant the request, that is then a permanent change to their terms and conditions. It becomes part of their contract that those are the hours that the individual is working. And if they want to change it back, they would have to make another request. And technically, if that is within the same 12-month period of the first request, as an employer, you're not required to consider or respond to that. You might do, depending on the circumstances, if you can accommodate it and you don't want to lose that employee. Again, thinking about kind of the difficulties of recruitment and stuff at the moment, you might be willing to be more flexible than you would in other circumstances. But yeah, if you've made a permanent change to the contract and then they want to change it, which would happen when you grant the request, and then they want to change it again, then they have to make a further request, and you consider it in exactly the same way, and there's no obligation to allow them to switch back again. So I think we've answered everything that's come in, unless, Rachel, can you see any other questions that are open? Oh, we've had a request for slides for today. Yep, absolutely. Yeah. We'll send the slides round, and we've got a recording of the session, so we'll send that round as well if that would be useful. So I'm conscious of time and the fact that obviously it's nearly Jubilee Bank Holiday weekend, and so everyone will want to be getting their celebrations underway or getting through the last bits of work before we finish up. So I hope today's been useful, and Rachel and I are available if there are any sort of follow-on queries from this. But otherwise, thanks for joining us. We'll send around our usual kind of feedback, so if there's something that you'd like to hear from us about, then please do feel free to suggest it. That's where this session has come from today, from previous suggestions of people wanting to hear about this. So we're always keen to make sure that our webinars are sort of topical and things that you want to hear about. So hopefully it's been useful, but otherwise have a great bank holiday weekend, and we'll see you again soon.
Thank you. Have a good weekend, everyone.